So I'm Alexis Watts, and I'm the Robina Institute's research attorney. And I want to introduce this project by talking about some of the people who I work with. Kevin Reitz is one of the co-directors of the Institute, and he's been really instrumental in this project. He has expertise in both sentencing and prison release. And that's really valuable in moving a project like this forward. My co-presenter, Ed Ryan, has a huge amount of experience as a practitioner in the reentry field, but also as an academic. He's the project director of the Robina's Parole Release and Revocation project, and is also an adjunct professor in sociology at Ohio State. So he'll be doing the second half of this presentation, and then we'll open it up for questions. We began working on this in the middle of 2017 because we've been studying indeterminate states for a really long time and seeing that there's a huge degree of variation in them. And we became curious about just how fixed the sentences in determinate states really are. And so why study this? Well, one of the reasons is we contend that prison release laws, policies, and practices are some of the most underrated contributors to mass incarceration. And what we mean by underrated here is that a lot of people have paid attention to sentencing and a variety of other factors that contribute to mass incarceration, but not as many have addressed the back end of sentences that are controlled by parole boards in indeterminate sentencing states or by other release mechanisms in states like Minnesota. We also recognize that supervision and revocation practices are contributors to mass incarceration, and we're looking at those in indeterminate states too. More research has been done already in this area, and we know that from that research that these practices hugely do contribute to mass incarceration. And we also find this area interesting because most jurisdictions share the supervision and revocation piece no matter what the release system is. So to start this project, one of the things that we needed to do was differentiate determinacy and indeterminacy, make a definition that would work for us in terms of our research goals. And we formulated the two definitions that you see here. Note that our definition is not about how states describe themselves, but it's about the reality of how predictable the sentence is from the defendant's point of view. So in a determinate system, we say that the actual incarceration sentence that will be experienced by the defendant is relatively predictable when the court imposes it. But in an indeterminate system, it cannot be as predictable because there will be other intervening decisions made that will affect the length of incarceration, like parole release decisions or good time credit decisions, things like that. So there's actually a continuum between indeterminacy and determinacy. Most states have some sentences that could be characterized as each. For example, in Minnesota, while most of our sentences are fairly predictable and most prisoners are released in around 2/3 of their sentence, there are also people who get life sentences for things like, first-degree unpremeditated murder is a good example that do still have to contend with discretionary parole release at the end of their longer sentence. Similarly, in a lot of states with parole boards, there will be some sentences that are, truth in sentencing style sentences or something like that, where the person does have to serve 85%. There are still mandatory minimums and such. And so no state is completely determinate or indeterminate. We also want to point out that the degree of determinacy varies within and between these determinate sentencing states. We are interested in exactly how determinate each one is. Our hypothesis is that there's some decision-making points in these jurisdictions that might allow there to be some flexibility in how much time is served on a sentence, even if it's just by a few months or so. The more people get to make decisions about things like good time, or as in Minnesota is the case, disciplinary time, or other factors that might lengthen or subtract the term, from the incarceration sentence, the more unpredictable that sentence becomes, no matter what, they're calling it. And we're interested also in how much violations of supervision can change the length of a sentence in certain jurisdictions. Finally, calling a system determinate does not make it so. Just to clarify, in some systems, even with parole boards, sentences are called determinate, and in a lot of cases that just means that the judge is setting a maximum term and that the release eligibility is then set by statute. For example, there are some systems that have parole boards that say, well, we have a determinate sentencing system because our judges sentence people to 5 years instead of 2 to 7 years. That's not our definition of determinacy and indeterminacy. Again, we want to focus on the actual predictability of the sentence itself. So to reiterate, we're focusing on predictability of the actual sentence experienced by the defendant. And for simplicity's sake, especially when we're doing sort of a ranking thing where we're looking from, most indeterminate to most determinate, we want to look at the majority of the cases in a jurisdiction. That makes it easier to actually figure out what jurisdictions are doing. We will be in our actual paper, we'll also be looking at some of the less common sentences in jurisdictions, but we want to focus a little bit on what happens to the average defendant. So some of our questions include how the initial date of prison release is decided, and how discretionary releases in actuality. We're seeing that in some of these states, for example, the Department of Corrections actually has a little bit more control over when people are released than they would just lead you to believe from looking at the description of how release works in a state. Can the length of term on the original sentence be extended due to revocation of release? Now, this is a really interesting question, especially in some states where what's going on is that if you get into trouble when you're on some sort of supervision after prison, they don't count all the time that you spent on supervision, and you're essentially starting from square one on that part of your sentence. We also wonder, and this is kind of the bigger global question, whether there are links between system design and incarceration and supervision rates. And we're also wondering about whether there's links between system design and the volume of revocations. So some of the goals of the project are to describe and compare and evaluate different determinate systems. So, part of the research that I actually think is really interesting isn't just aimed at answering these hypotheses that we were coming up with. It's just having the information, being able to say, aha, Florida is really different from Minnesota, and Minnesota is really different from Washington. So we're also interested in comparing determinate and indeterminate systems, especially in areas where we can make a direct comparison, like in post-prison supervision and revocation, which really are, in some ways very similar between all of the states, no matter whether they release is discretionary or not. And if possible, we then want to try to identify best and worst practices based on our findings. as our last step. So one of the innovations that we're trying to employ in this work is visual representation of sentencing and release and supervision. So we're making graphics that represent the timelines of a sentence from the sentencing event with the trial court all the way through to the end of the sentence to the point where the person is off paper for that particular case. And so just for an example, here's a really simple sort of Minnesota case. In this kind of case, the person has not received any disciplinary time while they've been in prison, so they're released at the 2/3 mark. They're a model releasee when they get out and while they're on supervised release, so they just serve 1/3 of their sentence and then they're just discharged from the system on that particular case at least. And here's a little bit more complicated a chronology just to see how we can try to use some of these visual representations. So this person has some disciplinary infractions while they're in prison and doesn't quite get out on time. They earn a little disciplinary time while they're in, and then they're on supervision, but they violate supervision pretty quickly, and they get 90 days revocation on a technical violation. Then they are released again, but then they have a new felony conviction, and under the regulations right now, they're eligible for release 6 months before the total end of the imposed sentence on this case, but not necessarily on the other felony case. So it will depend what their sentence is like for that other felony case about when they'll actually get out. And what we're interested in here is that we can use a visual like this just to depict what's going on in a lot of different states, because there's a lot of variation in how a chart like this would look. There might be some states where release occurred earlier or later than 2/3. There might be states where there's other factors in considering when somebody gets released. A lot of states, for example, have good time, and Minnesota has abolished good time and only essentially has bad time, the disciplinary time. There might be differences in how the supervision term is actually conceived of. For example, in some states, it's not a fraction of a total sentence, like 2/3 and 1/3, but rather it's a freestanding term of punishment in addition to the term of punishment that you serve in prison. So once on supervision, there might be different penalties for first or subsequent violations than you see here. Those could be really different between states. And there might also be, like I mentioned, time on supervision that gets forfeited as part of the revocation process, thus in effect extending the total length of the sentence. Whatever the case may be, we hope that it'll be clearer to everyone if we use visuals like this in representing some of these concepts. And now I'm going to turn it over to Ed Ryan, who's going to discuss some of our initial findings.
All right, I get the task here of sharing with you just at least preliminarily some of our initial findings. And I want to share that we are still very much in the early stages of our research. We're still gathering data. We're still comparing states. We're still going after additional research material to help augment and give us a better and more precise understanding of variations and differences between determinate states, and likewise some of the same sorts of distinctions and differences of what can we draw in terms of key markers between indeterminate states and determinate states. And one of the things that I want to talk about here is that, let me go back, is the fact that what has research already shown? And here I have to give credit to someone we've heard speak several times today, Kevin Reitz, and I want to talk a little bit on this slide just about something that is important to share, and that is that determinate states, on average, have lower prison rates than indeterminate states. And the reality is this: the volume and manner of prison release decisions have a significant impact on a jurisdiction's prison policy. But there's existed a long-held narrative, a narrative that I held for some time myself, but there's existed a long-held narrative that indeterminacy in sentencing and discretionary parole release fosters a notable leniency when it comes to offenders. And the reality is, the consequence of that is, it contributes to, at least within the framework of the narrative, a reduction in our overall rates of incarceration. And this narrative is also tied into the belief that the abolition or sharp curtailment of discretionary parole release, especially in tandem with the move to determinate sentencing systems, ended up over several decades serving as a crucial driver of prison population growth. And it's important to say that the reality is, during the period of time lasting from the last quarter of the 20th century through most of the first decade of the 21st century, during that period of time, states with indeterminate sentencing systems and discretionary parole release represented as a group the most prolific contributors to explosive prison population growth, or what we've come to refer to and heard a lot about today, mass incarceration. Now, another issue here, and it's important to point out that up until 2009, when prison rates seemed to go into a very modest reversal, rates of imprisonment had grown steadily across the country for over 3 decades. We've heard a lot about that. At year-end 2009, at the peak of the prison population explosion, 9 out of 10 states with the highest rates of imprisonment were those with indeterminate sentencing systems. So determinate sentencing states appear to have experienced less prison buildup during the era of rapid growth than states with indeterminate sentencing systems. Now, having said that, it's important to point out, nonetheless, when we shift the focus to determinate systems and we start asking questions about the structure and nature and manner of release in terms of those systems, determinate states vary widely in their prison release laws, policies, and practices. Now, many states, as many of you know, especially from the 1970s to the 1990s, adopted, in essence, truth in sentencing reforms, but they did so to varying degrees. And the reality is, as well, some states only implemented fixed prison terms. Others, like Minnesota, created sentencing commissions and a full and comprehensive set of sentencing guidelines. And what we find as well in our preliminary research is there are clearly other variations in terms of states that we have classified as determinate. But the variation in the character of the determinate sentencing structures in place across given jurisdictions remains a decisive factor in shaping differences in prison release laws and policies. And one of the areas that we are focused on and find to be very important here is that the degree of determinacy varies a great deal among determinate sentencing states. I think we have a tendency, when we talk in general about indeterminate sentencing systems and determinate sentencing systems, to make some assumptions about what we're going to find when we look more carefully at those systems. We know we are going to find the substantial exercise of discretion in indeterminate sentencing states, especially relative to discretionary parole release. But what about determinate states? And what we are already beginning to experience, not everywhere we look, but in some states, is we're beginning to find that the boundaries of determinacy are a little more permeable in determinate sentencing states than we believed coming into and beginning to develop our research. There is no, as Alexis said, no absolute or pure determinate or indeterminate sentencing state. Across determinate states, you're going to find small subgroups of offenders that may be found serving indeterminate sentences. In Minnesota, some murderers receive life sentences with eligibility for release. Some sex offenders are given indeterminate sentences in Minnesota to allow for the prolonged detention of those deemed most dangerous. So you see an element of indeterminacy within a very determinate sentencing state. The reality is, too, when we look at Minnesota, Washington, and Virginia, we see some differences. In Washington, regardless of the full term, prison term imposed, some offenders may earn good time release credits that will reduce their term of incarceration up to 50%. Up to 50%. Minnesota, as you just heard, offenders coming into the system will be released once they have served 2/3 of their maximum sentence. And likewise in Virginia, offenders who go to prison must serve at least 85% of their sentence before they are released. The critical factor in all of this is understanding what decisions are made, in what sequence, and by whom, and what is their cumulative impact on the proportion of offenders who are actually released at their projected release date coming in, whether that be 50%, 2/3 of the mark, or 85% of the mark. Now, we are also looking at the issue of post-release supervision and revocation, and I want to talk about those topics next. In terms of rates of post-release supervision, the reality is we heard Kevin Wrights today talk eloquently about the issue of mass punishment. And for some time now, for the last 2 to 3 decades, and with increased frequency, rapid prison population growth became recognized as mass incarceration. And likewise, although more recently than our recognition of mass incarceration has been the recognition of mass community supervision. Mass community supervision applies not just to mass probation, but it applies to mass parole supervision as well. But what's interesting is when we look at determinate and indeterminate sentencing states, we begin to see some distinctions between their rates of supervision post-release. They vary widely among indeterminate and determinate sentencing states, but are higher in indeterminate sentencing states by a ratio of 3 to 2. By a ratio of 3 to 2. Indeterminate sentencing states come in at about 300 per 100,000 adult population. Indeterminate states come in at roughly 200. And what's also interesting and important to note is that 10 of the top 12 states with the highest supervision rates have indeterminate sentencing structures. These differences, when you look more carefully at them, also reveal that a disproportionate representation of indeterminate sentencing states, not just at the top, but at that upper third in terms of highest rates of post-release supervision when compared to determinate states overall. When you flip it around and you look at rates of post-release supervision, what you find is in terms of indeterminate and determinate sentencing states, determinate sentencing states come in disproportionately low. The reality is that when you look at both determinate and indeterminate sentencing states, 11 states in each category come in with supervision rates at 200 or less. 200 or less. And what we thought would be helpful is just to share, without saying too much about this, if you exclude the District of Columbia at the very top and you look at Wisconsin, Wisconsin is the only determinate state that comes in over 400 per 100,000. And it begins to drop off from there. And if you also note, in terms of rates at the bottom, this particular chart showing supervision rates in determinate jurisdictions using BJS data from 2015, it only goes up to 900 per 100,000 adult population. If I shift the slide and we look at supervision rates in indeterminate jurisdictions, you can see the magnitude of difference I'm talking about. First, in terms of at the very bottom, where we move from the figure of 900 to 1,200 in order to accommodate the top states. Pennsylvania, Arkansas, and Louisiana come in as the top 3 states. If you look at that middle cluster, you've got a substantial number of states in terms of post-release supervision that come in at over 400 or butt up against between 300 and 400. And then when you go to the lower cluster of states, of course, you find the 11 states that I mentioned that come close to or at 200 per 100,000 population. Now, having said that, there are some interesting things to be said so far in terms of our findings regarding supervision practices. And one of the issues, and you heard Alexis speak to this, is the issue of the length of supervision terms. They vary widely among determinate and indeterminate sentencing states, and vary in terms of how the terms are determined, how they are determined. There are significant differences relative to the length of time offenders are expected to serve under community supervision post-release across the country. While the period of post-release supervision in some states is separate from the prison sentence, in other states, the other states authorize a period of supervision commensurate with the unserved balance of the prison term. And these distinctions, though, become more pronounced when you look at the two different categories that we've been comparing thus far. We took a careful look at 12 indeterminate sentencing states. And the predominant pattern found in the 12 indeterminate sentencing states, we'll be including all indeterminate states in our analysis eventually. In terms of those states that we considered, offenders may be required to serve the remaining portion of their sentence under community supervision. In fact, out of the 12, a total of 10 authorize a term of post-release supervision that ends upon the expiration of the maximum sentence. In terms of determinate sentencing states, we had information on 15 determinate sentencing states. And in terms of those states, a majority, close to 10, ended up not tying the length of supervision to the length of the prison term. Rather, the supervision period to be served is based on the felony classification or felony level into which an offender's crime of conviction falls. And so you find fixed periods of supervision time grounded in felony classification that may run for 5 years, 3 years, 2 years, 1 year. It's, in a sense, decoupled from the original prison sentence. The remaining jurisdictions, determinate jurisdictions, tie the sentence length to the period of supervision in some manner. Minnesota is such a state. Offenders are subject to supervision for the remainder of their sentence. That will have implications for some other comments I have to make in a moment. Whoa, what happened here? In terms of supervision practices and the imposition of the number of supervision conditions, many of you know that the primary activities of parole field services agencies reflect an overriding emphasis on ensuring parolees' compliance with the conditions of supervision. And as you look across the states and you look at conditions of supervision, in the aggregate, they are intended themselves cumulatively to ensure public safety. Conditions of supervision place an accent primarily on public safety. Now, in indeterminate states, paroling authorities or their equivalent impose the conditions of supervision. When those dozen states that we looked at in determinate sentencing states relative to what I'm calling standard conditions of supervision for now, just over half, 7 out of the 12, 58%, placed 10 or more standard conditions on those subject to supervision. So that is over half, placed 10 or more standard conditions on those subject to supervision. Now, when we look at determinate sentencing states, there's more variation in both the number of conditions and who authorizes them. But in the main, paroling authorities continue to play, even with this shift towards greater determinacy in sentencing, paroling authorities continue to play a primary role in most states, determinate and indeterminate, in setting conditions of supervision. In the 13 states that we looked at, in 9 jurisdictions, the paroling authority or its equivalent exercises this responsibility. And I share that as well to say that it appears that the volume of standard conditions imposed in determinate states is generally higher. It's generally higher. And in fact, 11 out of the 13 states, 85%, impose 10 or more standard conditions on those subject to post-release supervision. The reality is we are taking a pretty careful look, and further research on our part is already underway to look at special conditions of supervision, and especially to look at the conditions of supervision that involve the imposition of financial penalties or the imposition of supervision fees. We want to know more about that. And the totality of supervision conditions can either undermine or support the goal, if it's set, of both ensuring public safety and accomplishing meaningful and successful offender reintegration. And so this issue is an important issue to get to the bottom of. Likewise, in terms of determinate and indeterminate states, a slightly larger proportion of indeterminate states allow early discharge from supervision. There appears to be a modest difference between indeterminate and determinate sentencing states. Of the 12 indeterminate states that we reviewed, 9 out of the 12, 75%, provide for the opportunity to earn an early discharge from supervision. 3 indeterminate states do not authorize early discharge. In fact, what they do is to create administrative caseloads, which in essence removes the onus of routine reporting and compliance with some other conditions of supervision, but in essence, the offender serves a term of supervision up to the expiration of the maximum sentence. And technically, if arrested once again, can be brought back in terms of the revocation process. Within the 13 determinate states, 7 out of 13, 54%, authorize such discharge at least for some offenders. And they specify uniformly certain periods, minimum periods of time of supervision that must be met, and they also require certain behavioral or performance expectations while under supervision post-release. Early termination is not an option in another 6 determinate sentencing states. Minnesota may approve paper or administrative supervision, but does not relinquish supervisory control until the maximum sentence has been served. Now, revocation. I just want to make a couple of comments about revocation before I wind up my slides. Penalties upon revocation and reincarceration vary widely across determinate sentencing states. Now, I mentioned just a moment ago, in some states, the period of supervision after release is tied to the sentence. In others, they are separate or decoupled. What is important about this is that the consequences of revocation are different. The consequences are different depending on the relationship with the original sentence. What's at stake if an offender is revoked and returned to prison? In Minnesota, an offender may be reincarcerated for the remaining 1/3 of the original prison sentence. In Ohio, my home state, reincarceration may occur for up to 1/2 of the term of the sentence originally imposed on the offender, even though the supervision term imposed might be significantly shorter. In Virginia, offenders can only be reincarcerated up to the remainder of the supervision term after revocation. So if an offender is serving a 3-year term of supervision, at the outset, the maximum they can be reincarcerated for is 3 years. Now, another really important issue, and I think this will be a sleeper issue that will come to the fore and be very influential in what we write down the road, and that is to what extent and whether credit is granted for time served on post-prison supervision. And what we've noticed already is that it varies quite widely across the states, across determinate states. There are notable differences among the determinate sentencing states in how the supervision period is counted toward the total term remaining after an offender violates the conditions of supervision or is revoked. In North Carolina, revocation means the offender will get no credit for any days served on supervision. What that means is not only is the supervision period told by violations at the point that the warrant is issued, but all of the time leading up to the violation is forfeited. That's a big distinction. In Arizona, how much street time is lost is discretionary. The determination of how much street time to seize is discretionary. In Washington, the issuance of a warrant for an arrest on a violation tolls the period of supervision. But the reality is offenders get credit for the supervision period leading up to the warrant. So there are marked variations just in those 3 states. We expect to find significantly more in the way of variation, and of course we'll compare that with indeterminate sentencing states as well to see where we land. One more piece on revocation, and this is more of a generalization than a research conclusion. It's preliminary, but the reality is that procedures for the exercise of release and reincarceration discretion vary in quality across determinate sentencing systems. We're in the process of developing markers to explain that kind of observation further and to determine to what extent it holds across those markers as we conduct further research. But the reality is that there are some states where revocation decision-making is structured and revocation is limited, whether through structured progressive sanctioning grids or other kinds of tools, where the time that can be served on supervision is predictable and known going in, and where the amount of reincarceration possible at revocation is predictable. Thus far, we find that, at least in Washington and Minnesota, that's a generalization that seems to play out in these respective jurisdictions. There are other states where various facets of the revocation process, the reincarceration and revocation process, make some of these factors less predictable. I've shared a few of those. But to the extent this happens, it contributes to less determinacy in the life course of prison sentences within these systems. And that may itself become an important finding in the months ahead. So having said that, let me draw this to a close so we have some time for questions. We just have 4 final comments under conclusion, one of which is, and you heard us start with this comment, the idea that, and the argument that prison release laws, policies, and practices are the most underrated contributors to mass incarceration. You know, it's surprising that it took as long as it did for academics and scholars and even policymakers to recognize and begin to frame prison population growth as a matter of mass incarceration. It took a lot of work. It took some comparative work with Europe and other countries, but we finally reached that point. But what we still haven't done is to take a careful look at both determinate and indeterminate sentencing states and find those doorways in that represent the exercise of discretionary decision-making that contribute in a way that isn't always transparent, more time to be served. And that applies at the point of prison release all the way through the continuum. Supervision and revocation laws and policies and practices are important contributors. We heard about that this morning, but what we also understood and heard from this morning's presentation is that we know something about that. There has been some academic and policy research directed at the impact of the violations process, regardless of whether you're talking about indeterminate or determinate sentencing states, the impact the violations and revocation process has had on prison population growth over time. I recall in the year 2008, 36% of those coming in as admissions to prison at the front end were parole violators. 36%. We heard today it's down probably around 25, 26%. But it's a phenomenon that we have a better understanding of, but we still want to understand in determinate sentencing states the nature of the interdependency and the interdependency in terms of markers that are connected that reflect cumulatively the exercise of discretion, and how that either contributes to more time served in a manner that is either predictable or not, or just the factors that contribute to more time served relative to supervision practices and policies and revocation practices and policies in indeterminate and determinate sentencing states. We also, in terms of this project, as Alexis shared, determinate states may differ from each other and from indeterminate states in many important respects. We expected and expect still to find significant differences in terms of the markers we establish for comparing indeterminate and determinate sentencing states. But our growing sense, and I suggest that it's probably stronger than a growing sense, is we're going to find significant differences and significant markers that reflect pronounced variation within states that to date we have called determinate sentencing states and made assumptions about their transparency, their consistency, their fairness, and their predictability. And with that, I'll adjourn my comments and open up the floor for any questions that the group may have. And you can ask, Professor Reitz is with us here. We're not excluding him from, despite his generous presentations throughout the day, we're not excluding him from helping us answer questions that you may direct towards us initially.
Well, thank you. Carl Reynolds from Texas. I want to propose a little mission creep to you. Maybe get your hands on a Sparky grad student to add another dimension to this. It sounds like you're going to need to look at the way that prison systems administer their disciplinary process. Good time, earned time, bad time, taking time away from people, giving them time. What I'm interested in is whether there will be the possibility of seeing differences in prison behavior in determinate sentencing states. You know, the rap on determinate sentencing is there's no incentive to behave. In Texas, we have Part of our system, it's hybrid. Part of our system is completely determinate, and the rest of it is very indeterminate. The corrections administrators tell us they have a lot of trouble with people in the determinate system. There is no incentive. There's no good time. There's no discretionary release mechanism. So I'd be really interested to know if this project could creep into some kind of way of comparing the rates of disruption within prisons because of that feature of a lack of incentive to do well.
That's a great question, Carl. And I will say that first and foremost, when we look across the architecture of the life course of prison sentences and determinate sentencing systems, one issue that we have to look at both within and across determinate and indeterminate systems is the earned credit, provision for earned credit. Good credit time, earned credit time, minimum custody time, just all the myriad definitions that define eligibility that may impact on the nature of your sentence and the length of time you serve in prison before going home or going out to post-release supervision. And we are going to have to look at disciplinary time in states, as Alexis said, Minnesota has bad time. That clearly can delay that 2/3 mark. Part of what we need to know across every determinate state that has laid out a projected date of release coming in is what impacts on that. And one clear factor we will look at is the issue of bad time. Or I'm using bad time as a metaphor for time taken added to your sentence for disciplinary reasons. But we're going to have to take a more careful look at indeterminate sentencing systems as well. We've not done that to date. Thank you.
My name is Joe Mayer. I've been a parole officer in St. Paul since 1991, or maybe longer if I just can't remember beyond that. And I heard you talk about how supervising agencies in research either primarily enforce conditions or do other things, and I didn't understand what else they do and how research decides what else they do. So I was just curious how you decide in research either if they enforce conditions primarily or what else they primarily do and what is it that they do.
Yeah, and that's a fair question. What I haven't talked about and what we haven't researched, although we could draw on some research that is out there both in the probation side and the parole supervision side, is the issue of philosophy of supervision, approaches to case management, tools used whether for risk management or the assessment of criminogenic needs that route people to appropriate program options in the community. Those are all things that go on, and we'll deepen the analysis where we can by bringing that larger context to the table in terms of what we write here. We just didn't for this presentation. I think it is fair to say, and argue with me if you would disagree, that as a broad generalization, the conditions of supervision, and certainly the standard conditions of supervision, put the accent on ensuring compliance with public safety and routine reporting, notification of where the offender is residing, reporting requirements, if you're going to travel out of state, getting permission to do so beforehand. In other words, staying connected to the hip with your PO is your responsibility primarily, and the PO is going to enforce compliance with that.
I don't think training and orientation around how we're supposed to supervise necessarily do that. I think we're trying to help reintegration and adjustment.
I wouldn't disagree with that. I think that's a fair statement. And I think, too, what's important and what we didn't say enough of in a short presentation like this is that the conditions of supervision can serve to support a successful supervisory conclusion, a successful conclusion to the term of supervision, and at times that is the intent, especially behind special conditions and more. But as you impose a broad band and width with real specificity to conditions of supervision, we get concerned in some of the work we've done in Robina that offenders get overwhelmed. They don't have that broad bandwidth that can accommodate all of this, and even if there are violations, they may not be intentional because they see this much, they don't see this much. So inadvertently, if we don't reduce the volume of and nature of supervision conditions, we may from the outset be setting them up for failure. And that's one reason we want to take a careful look at just the sheer number of conditions that are imposed, standard, special, and whatever else we may find. But I appreciate your comment.
Thank you, Professor Ryan. And Professor writes, you wrote an article with, I think it was Joan Petersilia, about this issue, and had a suggestion about considering maybe 4 standard conditions of release, and there's 13 in Minnesota currently. And we've been in conversation. I'm Lars Dexter with Isaiah. We're a faith-based organization working on this issue. And we've been in conversation with our Commissioner of Corrections about this issue over the last couple of years because it is such a driver of the prison population increase in our state, or the overpopulation problem. So I'd be curious, like, how much is your research able to drill down on the policies and having those 13 standard conditions as opposed to the practices and kind of the culture of the department in enforcing that, and some of those softer factors that might, if there's an attitude of kind of catching out the bad guy and sending him back within that department, for example, as opposed to really working with people to help them be successful, then that obviously you're going to have very different outcomes. So I'm curious if your research is quantifying or documenting that.
Well, I think, and I'm open to any comments Alexis may have as well as Kevin, but I think for now what I anticipate, given the kind of research we're going to do, is that we'll draw on secondary sources for information on that, not conduct our own original research, although we may find some states that we do bore down into and try to make some of those determinations. I had the fortunate opportunity for a number of years to serve as the Director of Field Operations for the Georgia Board of Pardons and Paroles, which was parole field services statewide. Culture matters a good deal. Training matters a good deal. Policies do direct and shape practice, even if there are significant disconnects at times. And so some of that is on our mind. How much of that we can bore down into in terms of original research is probably going to be limited. But we're at the early stages of this project, and it may acquire its own life course, to use a term, and different stages of analysis as well. We may find that there are a core of determinate sentencing states that represent some of the variation and complexity across markers that we want to know more about, and that's when we would probably reach out to those systems and those contact points to find out more. And to some extent, we've been doing that already to get release data around releasing policies, where we want to know and make sense of that projected date of release and how much certainty and predictability is there to that. And if the proportion of those that are projected to go out are very, very high, then we know what we conclude. If it's very, very low, what accounts for that? But what accounts for any variation, period. Yeah.
And I mean, one of the things that we will be including is, it's because it's something that's fairly simple data to gather, is looking at rates of revocation. Mm-hmm. And mm-hmm. that, while there are a lot of factors that can explain rates of revocation, one of them, to some extent, is going to be what policies exist around supervision and how easy or difficult it is for people to follow those rules.
Good afternoon, Tom Roy, Commissioner of Corrections. I'm one of the few vertical practitioners that still remember the old system. I started 43 years ago under Indeterminate.
Oh my God!
I was.
Huh.
Oh.
I
thank somebody.
I feel like a peer. So.
I think, and I'm kind of surprised that we haven't had any comments today about the impact of sentencing guidelines in the practice of plea negotiations. And in your analysis, I sure hope that you have some sense or can give us some direction as to the impact. And what I saw under the old system was plea negotiations varying greatly, and the acceptance of those plea negotiations by varying courts, rural, urban, and the great impact of sentencing guidelines and determinate sentencing really has been to give discipline and a template for plea negotiations for county attorneys, who are the most powerful people in the state. It's a starting point. I think the real rub is going to be in your analysis of decision points, what those local variations will be. because if you look at the sentencing report produced by the Sentencing Guidelines Commission here in Minnesota, by judicial district, there is incredible variation in departure rates, in sentence length by different crimes, and much of that is related to plea negotiations. So even with a system of determinacy, that county attorney and that judge have incredible power to adjust that sentence. And it's very primal decision-making in terms of justice.
Thank you. Thank you.
Thank you.
And thanks for joining this session, to all of you. We still have a few minutes if there are any other questions. The lone straggler.
Sorry, and you may have answered this question already, but in your analysis, have you found between indeterminate and determinate sentencing differences in sentence length and length of stay?
Good question. We haven't looked directly at that. We could make some generalizations about that, and because where a significant percentage of determinate sentencing states decouple the term of supervision from the sentence imposed, that decoupling, from what I can see, and this is not a comprehensive and full review, that decoupling represents what look like shorter, definite periods of supervision graded by felony classification or offense. And most indeterminate sentencing states are going to call for service of the supervision term for the up to the maximum sentence. And what we don't know there, and what we need to find out about, is to what extent, when you come out under an indeterminate sentencing scheme, and you're expected to serve the time post-release that remains up to the maximum sentence, how many do that, and what's the role of early discharge in moving that back or addressing that kind of time frame? And creating both length of stay in prison, of course, is going to be different, but length of stay under supervision. I think truth in supervision, as opposed to truth in sentencing, is something we're going to start looking at a lot more closely, and its nexus to revocation policy and practice. That's a good question. Go ahead.
I think we have time for maybe one more quick question.
Bob Tennis, I'm wondering whether or not you'll be looking at the terms and conditions not only for parole but also for pre-diversion programs like probation instead of prison, and whether or not those terms and conditions are such that failure is pretty well guaranteed.
We have not. The short response to that is we have not and do not have plans to do so in the main, because this is really focused on the state level work that paroling authorities conduct, determinate sentencing systems perform, and how that all connects in terms of its inner architecture, as I said, at the state level. And
And I might just add to that.
Yeah, would you
do
please?
have other projects in the Institute
yes,
that are addressing
yes,
that problem.
that's right.
But not this particular one.
Yeah. Well, we appreciate your willingness to come out and listen to this discussion. And if you've got any further questions, you want to see us afterwards, feel free.